How we doing today, guys? It's Jesse with the Common Man Corpus Christi, bringing you news and politics through our common sense lens. And it's a beautiful day in America because according to a reported leak last night from the Supreme Court that Politico got a hold of, looks like the end of Roe v Wade and Planned Parenthood versus Casey is finally going bye-bye, and we are now going to be allowed to determine the future of abortions in the United States by the state-by-state level, which I think if you know how the majority of these states feel and some of the trigger laws, you'll see that this is going to be more or less an end to abortion in the majority of the country in the United States when this ends up coming down. So we're going to get into this article. We're going to read all the details that Politico has. We're also going to check out a little tweet from over here at Josh Hammer, who has some interesting theories onto what happened and where this leak might have come from and his reasons behind that. So we're going to get into all of that. We're going to check out this article, and we're going to celebrate in the beauty of the fact that it looks like this horrible bastardization of the Constitution, claiming that abortion is a right, is now going to finally go away and be placed back in the places it properly belonged, which was states' rights. So, here we go, from Politico.com. Oh, and if you do enjoy my content, hit that like button, share it with all your friends, and subscribe, and let me know what you think about this down in the comments. So here we go. Supreme Court has voted to overturn abortion rights, draft opinion shows. We hold that Roe and Casey must be overruled, Justice Alito writes in an initial majority draft circulated inside the court. Beautiful. Here's all the crazy nut jobs. These people literally showed up last night at the Supreme Court. There was both sides. There was pro-abortion, and then there was anti-abortion protesters that showed up last night as soon as this was leaked. It's wild how fast they got on all of that. The Supreme Court has voted to strike down the landmark Roe v. Wade decision, according to an initial draft majority opinion written by Justice Samuel Alito, circulating inside the court and obtained by Politico. The draft opinion is a fully throated, unflinching repudiation of the 1973 decision which guaranteed federal constitution protections of abortion rights, and a subsequent 1992 decision, Planned Parenthood versus Casey, that largely maintained that right. Roe was egregiously wrong from the start, Alito writes, and that he is so right. We hold that Roe and Casey must be overruled, he writes in the document labeled as the opinion of the court. It is time to heed the Constitution and return the issue of abortion to people's elected representatives. Hear, hear. Now, we're going to have to read through this whole thing because it is really, really, really long, but we'll check out the highlights from Politico. Deliberations on controversial cases have in the past been fluid. Justices can and sometimes do change their votes as draft opinions circulate, and major decisions can be subject to multiple drafts and vote trading, sometimes until just days before a decision is unveiled. The court holding will not be final until it's published, likely in the next 2 months. A lot of people honestly think, though, that this leak, because of the fact that it happened, they are going to have to ramp up the time period on that one. And some people even think this might end up being out by the end of the week. If not, we might hear something from the court by the end of today as well. Because this fact is, they leaked this, so they need to come out and respond to this, because the Justice Roberts this morning already confirmed the fact that this is completely real, this is truth, and they are going to use the Marshal Services to investigate this and try to find out who leaked this. And if they find out who it is, consider your law career over, because this is a major violation of not only the trust of the court, but just general ethics. The immediate impact of the ruling, as drafted in February, would be an end to a half-century guarantee of federal Constitution protection of abortion rights, the ability to murder your children, and allow each state to decide whether to restrict or ban abortion. It's unclear if there has been significant changes to the draft. No draft decision in modern history of the court has been disclosed publicly while a case was still pending. The unprecedented revelation is bound to intensify the debate over what is already the most controversial case on the docket this term. The draft opinion offers an extraordinary window into the justices' deliberations in one of the most consequential cases before the court in the last 5 decades. Some court watchers predicted the conservative majority would slice away at abortion rights without flatly overturning a 49-year-old precedent. The draft shows that the court is looking to reject Roe's logic and legal protections entirely. So yeah, that's what a lot of people thought, that Roberts was going to try to take the majority opinion on this, and so that way he could kind of do like a split the baby kind of thing, is yes, uphold Mississippi's law on ban of abortion after 14 weeks, but still allow basically that everywhere else. So it looks like that's not what's going to end up happening, and I'm really happy to hear it. A person familiar with the court's deliberations said that 4 of the other Republican-appointed justices, Clarence Thomas, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, had voted with Alito in the conference held among the justices after hearing oral arguments in December, and that lines up remains unchanged as of this week. The 3 Democratic-appointed justices, Stephen Breyer, Sonia Sotomayor, and Elena Kagan, are working on one or more dissents, according to the person. How Chief Justice John Roberts, who was also a Republican appointee, thanks Bush, will ultimately vote. Whether he will join an already written opinion or draft his own is unclear. The document, labeled as the first draft of the majority opinion, includes a notation that it was circulated among the justices on February 10th. If the Alito draft is adopted, it would rule in favor of Mississippi in the closely watched case over that state's attempt to ban most abortions after 15 weeks of pregnancy. A Supreme Court spokesman declined to comment or make another representative of the court available to answer questions about the draft document. And like I said, that's already changed this morning. This was the original article from last night. I want to go to the original source on that one. And that, like I said, Roberts already confirmed that all of this is true. Politico received a copy of the draft opining from a person familiar with the court's proceedings in the Mississippi case, along with other details supporting the authenticity of the document. The draft opinion runs 98 pages, including a 31-page appendix of the historical state abortion laws, which is why we're not going to read through that thing. It's 98 pages plus a bunch of appendix stuff. But I do highly recommend you go through and read it if you have time on your own, but obviously that would be way too long for a video over here and would not do it justice. The document is replete with citations to previous court decisions, books, and other authorities, and includes 118 footnotes. The appearances and timing of this draft are consistent with court practice. The disclosure of Alito's draft majority opinion, a rare breach, and it's honestly an unprecedented breach in modern times of the history. I think the last time anything like this was done, I don't even think anybody could come up with one. The disclosure of Alito's draft majority opinion, a rare breach of Supreme Court secrecy and tradition around its deliberations, comes as all sides in the abortion debate are girding for the ruling. Speculation about the looming decision has been intense since December. Oral arguments indicated a majority was inclined to support the Mississippi law. Under long-standing court procedures, justices hold preliminary votes on cases shortly after arguments and assign a member of the majority to write a draft of the court opinions. The draft is often amended in consultation with other justices, and in some cases, the justices change their votes altogether, creating the possibility that the current alignment on Dobbs versus Jackson's Women's Health Organization could change. Hydration break. I think one of my only real issue with this here is, and I've heard this spoken by other people, is the fact that if they do this, right, then it will prove that the court can cave to political pressure. And if that's the case, your legitimacy of that court is completely gone out the window. And if Roberts' only intention is to protect the integrity of the court, they're going to have to come out with something on this fast. Because if they change their minds, if this opinion changes, or if the justices change their votes, that's going to show you it's nothing more than a kangaroo court and it's just a bunch of politics, and that we're just going to have to start ignoring them and do our own thing, because that's what the rights the states give us, and that's what the 10th Amendment of the Constitution gives us, the ability to ignore them if we think they're doing something wrong. The Chief Justice typically assigns majority opinions when he is in the majority. When he is not, the decision is typically made by the most senior justice in the majority. Exceptionally weak. A George W. Bush appointee who joined in 2006, Alito argues that the 1973 rights abortion ruling was an ill-conceived and deeply flawed decision that invented a right mentioned nowhere in the Constitution and unwisely sought to wrench the contentious issue away from the political branches of government. Alito's draft ruling would overturn a decision by the New Orleans-based Fifth Circuit Court of Appeals that found Mississippi law ran afoul of Supreme Court proceedings by seeking to effectively ban abortions before viability. Roe's survey of history ranged from the constitutionally irrelevant to the plainly incorrect, Alito continues, adding that its reasoning was exceptionally weak and that the original decision had damaging consequences. I love that they're actually quoting so much of Alito and just trying not to make a hit piece out of this. The inescapable conclusion is that the right to abortion is not deeply rooted in the nation's history and traditions, Alito writes. Alito approvingly quotes a broad range of critics of the Roe decision. He also points to liberal icons such as the late Justice Ruth Bader Ginsburg and Harvard law professor Lawrence Tribe, who at certain points in their careers took issue with the reasoning in Roe or its impact on the political process. Alito's skewering of Roe and the endorsement of at least 4 other justices for the unsparing critique is also a measure of the court's rightward turn in recent decades. No, they're just going back to being an actual constitutional court like they're supposed to be, and making sure that the states get their rights and the federal government doesn't violate the states' rights. The overturning of Roe would almost immediately lead to stricter limits on abortion access in large swaths of the South and the Midwest, with about half of the states set to immediately impose broad abortion bans. Any state could still illegally allow the procedure. Exactly! Leaves it back up to the states. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion, the draft concludes. Roe and Casey aggregated that authority. We now overrule those decisions and return that authority to the people and their elected representatives. Oh, yeah. The draft contains the type of caustic rhetorical flourishes Alito is known for, and that has caused Roberts, his fellow Bush appointee, some discomfort in the past. At times, Alito's draft opinions takes an almost mocking tone at the skewers that the majority opinion in Roe, written by Justice Harry Blackmun, a Richard Nixon appointee who died in 1999, Roe expressed the feeling that the 14th Amendment was the provision that did the work, but its message seemed to be that the abortion right could be found somewhere in the Constitution and that specifying its exact location was not of paramount importance, which means it's not constitutional. If it's not in there, you can't just make it up. Alito declared that one of the central tenets of Roe, the viability distinction between fetuses not capable of living outside the womb and those which can, makes no sense, especially with technological advances as they keep coming. In several passages, he describes doctors and nurses who terminate pregnancies as abortionists. He's right. When Roberts voted with liberal jurists in 2020 to block a Louisiana law imposing heavier regulation on abortion clinics, his solo concurrence used the more neutral term abortion providers. In contrast, Justice Clarence Thomas used the word abortionist 25 times in a solo dissent. God, I love him. All right, so we're not going to go through, we're not going to go through the rest of this because this is literally just going down in the history, nods to conservative colleagues. While Alito's draft opinion doesn't cater much to Roberts' views, portions of it do seem to intend to address the specific interests of other justices. Have changed drastically. One passage argues that social attitudes towards out-of-wedlock pregnancies have changed drastically since the 1970s, and that increased demand for adoption makes abortion less necessary. Yep. So, but it's one of those, I'm not going to go over this whole thing because you guys can read the article. I'll post it on my social media on my Twitters. It's definitely already over there. And then as well onto the Facebook page. This article will be on there as well as this video. That's where that will be posted. But I'm not going to, like I said, we're not going to go into the complete history. If you want to do that, you can look it up yourself, read the whole article because they're going to go into the history of all these cases and how far it goes back, even involving Plessy versus Ferguson. And a lot of the other stuff that has to do with contraceptive and all of the entire history of how this goes. You should go through and read the history. If you don't know the history of a lot of this abortion stuff, I highly recommend you go check it out. All right, so before I carry on with the rest of this and give you my opinion on all of this before we completely go, let's go back over to Josh Hammer real quick because I didn't want to miss this. I want to make sure this gets added into the video because I want you to see what he says. So this starts out with Josh Hammer over here, and this is from the original Political article from last night that we just went over. But my norms, huffed the disaffected leftist SCOTUS clerk as he checks notes, leaked the biggest story in modern SCOTUS history. Now, Josh Hammer is like a hardcore, like, legal analyst. Like, he's been, opinion news editor, but he's like a lawyer and all that other kind of stuff. Like, this is a guy that follows the Supreme Court and all of this kind of stuff hardcore. All right, Sotomayor's Chambers is definitely the best guess, but impossible to rule out the possibility of Kagan or a Breyer clerk. So he thinks, he definitely has his opinions on this. As if we needed yet another reminder that the left will stop at nothing to preserve its foremost pagan sacrament, abortion. We get the biggest leak in SCOTUS history. Vile stuff, which is one of the big issues everybody has with this. This is a severe breach of decorum, ethics, and honest-to-God, just legal matters when it comes to the Supreme Court. It's absolutely horrible that they leaked this because it completely makes it really, really hard. And they did it intentionally just to try to force them to change. Most likely a Hail Mary plea here. Rogue Sotomayor clerk, again, maybe Kagan or Breyer clerk, wants to, 1, sick Antifa nutjob protesters outside Kavanaugh or Barrett's home, and or 2, get Democrats to pack the court before Congress' August recess. Zero chance that happens, to be clear. I hope he's right. As I've written before, when it comes to SCOTUS, there are 2 types of rules. Rules for abortion and then rules for everything else. So that's Josh Hammer's opinion on that. I really enjoy his opinion on this kind of stuff. I think he's a great legal analyst, and that's why I like his stuff. And I believe his opinion here is probably correct. We have a pretty good idea of where this was probably leaked. They don't think it was probably from one of the actual justices themselves because the justices have to work with these people for the rest of their lives. So we don't think it's one of them, but it definitely would not surprise us if it was one of their clerks, and that's probably going to look at it a disbarment for that clerk. So that's probably going to end up in a disbarment for that clerk. So let's go back into everything else because they basically just made this shit up. Like, completely and totally. Whole cloth, just poofed it out of thin air. Like there is no justification whatsoever in the Constitution for abortion or the right to an abortion. There is no right in the Constitution whatsoever to murder your children. It's just not there. And the nice part about this is once this comes out, once this is made official, that means the states now get the decision to decide what they want to do with abortion. And that's exactly how our system is supposed to be set up. That's exactly how the federalism is supposed to work. Each state is supposed to be its own little science experiment. We are supposed to be able to do things that work best for us. And then if they work really well, other states will adopt them, or maybe we'll even adopt them on a federal level. But that's only after these experiments have happened in states. And there's certain things the federal government just can't do. And the right to murder your children is one of them. So I'm really glad to see this. Praise the Lord that this is happening. And just remember, thank Donald Trump, because 3 out of these justices were his appointees. So he might be morally corrupt. He might be a rotten guy that says a lot of mean things. But at the end of the day, all there is broken people. All there is people with issues. And God's going to use all of us as a vessel for his will. And that's exactly what I believe we saw last night when this was leaked. I believe that's exactly what we're going to see now in the future as this goes forward. God's going to use any one of us, no matter what kind of rotten vessels we are. He will use us for his will, and his will be done. But hey, guys, that's just my common sense take. This is Jesse with the Common Man Corpus Christi, bringing you news and politics through a common sense lens. If you do enjoy my content, hit that like button, share it with all your friends, and comment down below. As always, thanks for watching.